So now I would like to introduce a colleague of mine, so Christopher Sykes. Chris is a senior lecturer and program lead for the LLM Legal Practice at Manchester Law School. He was a criminal defense solicitor, primarily practicing in the area of white-collar crime. He then worked as a teacher of legal skills and law in Spain before co-founding the Hong Kong-based legal tech business, Zegal. And he's here since worked as a lecturer at BPP Law School. His main area of interest is legal technology. So Chris, the floor is yours.
Brilliant. Thank you very much for having me. I feel under some pressure now to finish in exactly 10 minutes, as Gitano did. Now, I'm going to talk to you today about disclosure and AI, and this is my way of combining two interests of mine. So, as Costa said, I used to work as a criminal defense lawyer in the area of fraud, and now I'm very much involved in legal technology. One of the aspects of that, of course, is to be involved in artificial intelligence. Okay, so a bit about my background. In complex crime cases and fraud cases, there's a lot of what we call disclosure. For those of you more familiar with the American system, you might call this discovery. So you served an awful lot of paper, and when I used to be in practice, it involved going through tens of thousands of bits of paper. On one occasion, it involved standing in a skip and going through paper that had been thrown away. Eventually, of course, prosecuting authorities moved to using DVDs. That didn't always make things any better. They just put schedules of documents on DVDs. And one of the big features of working in criminal defense and around disclosure is that when you're looking through documents, you don't know what you're looking for in the first place. You may have a look and find nothing, or you may find something that's really useful. Now, what is disclosure? Disclosure is where the prosecution provides the defense of copies of materials that are capable of either undermining the prosecution case or assisting the defense. Now, I've put a little quote on there. I won't read through that. There's been a lot of publicity in the UK recently about failings in disclosure, often down to human error. There you can see that the CPS, College of Policing, and National Police Chiefs Council are aware that this is a problem. I've set out the law there. I'm not going to go into that in any detail, but CPIA states what the prosecutor must do. They must disclose information that might reasonably be capable of undermining the case of the prosecution against the accused or assisting the case for the accused. And one of the aspects of this is that a defense statement is served by the defense, and this triggers the disclosure officer, often a policeman, but sometimes a lawyer, to direct their attention towards disclosure of unused materials. There's been a few high-profile cases. I'm focusing on the SFO today, the Serious Fraud Office, because they're involved only in complex crime involving quite a lot of paperwork. They've had various trials collapse. This trial, you can follow the link there. Crown and Woods involved a series of recommendations, and one of the recommendations was that the SFO should consider resourcing this area, this examination of unused material, a lot better. The SFO in response have said that they're bidding for additional funding, that the amount of documents involved in disclosure is increasing year on year. Of course it is, we use technology more, there's more data out there, it's a big problem. It's becoming the case that human beings are just in, not in a position to do this. So with big publicity, the SFO announced that it was starting to use open text, use a robot lawyer, to use AI to assist it. That makes complete sense, of course, using modern technology to do something that humans are struggling to do. But this causes us some problems. So we've got a traditional legal framework around a traditional legal thing, that involves human beings looking at documents and deciding whether or not they need to be disclosed. What can go wrong? Lots of things can go wrong. The Attorney General's guidance on disclosure, which you can read in your own time, says that technology can be used for disclosure. It says technology that takes the form of search tools, which uses unambiguous calculations to perform problem-solving operations, blah, 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 can be used. Does AI fall within this category? Well, no, it doesn't, does it? Unambiguous calculations is perhaps needs to be defined a little bit more, but we don't know what kind of calculations AI does. So what would happen in the past is if there was a problem with disclosure, then you could say, well, this human being has done it wrong, we need to re-review it. The courts need to have confidence that disclosure is being done properly. So for example, where is a human error? The caseworker understands the terms of the review, but they make a mistake. Now the human can explain that fault. The court can say, go away and review those documents again. But if we're using AI, how do we know that the AI has applied the search terms correctly? Can the SFO explain to a court what's in that black box, what's in that algorithm? And I've been trying to think about this, and it's a difficult thing. How do we ensure that a court does have confidence in an algorithm which reviews and identifies, and this has been mentioned earlier, I think by Paul, that does disclosure? I don't see any way that this can be the genie can be put back in the bottle. It has to be the case that we use AI for disclosure, but how is that going to work? So I've got no answers here, but just a few questions to put to you. Do we change the Attorney General's guidance? Okay, so that's one idea, that we carve out a broader definition of what's considered a unambiguous calculation. Do we even consider changing the law in actual fact? The well-established disclosure rules on unused material, which were put in years ago to avoid miscarriages of justice, such as the Birmingham 6, these famous miscarriages. Do we say, right, we're abandoning AI and return to manual review? That's going to get it's going to get harder and harder, isn't it? Millions of documents. Might you use to establish for the court, might you have a sample review so that the court can see that it's been done correctly on a very small number of documents? Do we bring in expert witnesses to verify to the court, experts in computer science? Do we need to change the law on disclosure? I've mentioned that already. Or are there technological solutions out there? So, in summary, we've got a law and regulation which works as long as we're confident that we can identify what the search parameters are. So I'm not suggesting any change in how unused material is approached, as long as human beings can look at it. But are we going to see in the future defence teams saying, well, Your Honour, how can we possibly be confident that these documents have been reviewed properly and that the unused schedules are accurate and that certain documents just haven't been buried away in the paperwork? So there's just a few questions to put out to you there. If anyone wants to have a chat about this, I'll put my email there as well. That's about it. Oh, wow, brilliant. Oh, I'm glad I didn't go through all the legislation.
So, okay, so Chris, thank you very much. I mean, thank you for highlighting this current burning issue on disclosure, and I found it particularly interesting, Chris, because you focus on the SFO cases Also because before undertaking my academic career, I worked for this highly specialized London-based prosecuting authority, and I was in anti-bribery division, and I remember quite well what it meant to document review over a couple of million emails in a team of 10, and this is not a random number. So to take into consideration that corporate investigation, in corporate investigation, usually the evidence is disclosed by the corporation itself, and you just corroborate this. So we can speak about that a lot, but basically it's clear to me that are both advantages and challenges in applying these technological tools in corporate crime investigation. So this is a very, very problematic area that we should look carefully. So now.